In July 2018, India and the United Kingdom had signed a memorandum of understanding for cooperation in the area of law and justice. The MOU has enhanced the engagement between the two countries and paved the way for a greater collaboration and exchange of expertise across areas including the rule of law, dispute resolution, training, and legal services resolution. Under the agreement, a joint venture committee was also formed to identify the key areas of collaboration. The bond has been further strengthened by the signing of a free trade deal between two nations this year, a step that is set to significantly enhance bilateral trade and economic cooperation. As we move forward, building a future that is rooted in mutual respect, collaboration, and commerce, it is imperative that we also cultivate new mechanisms for dispute resolution that reflect our shared commitment to fairness and efficiency. As is the case with any form of commercial activity, disputes are an inevitable part of the process. What truly matters, however, is not the existence of these disputes, but rather our capacity and commitment to resolving them efficiently and effectively. The manner in which we address and settle conflicts is what defines the strength and resilience of our commercial relationship. This is where a well-established, fair, and accessible dispute resolution framework becomes crucial. Such a framework ensures that disagreements do not undermine trust or hinder progress. Instead, they become an opportunity for constructive engagement, promoting long-term cooperation and stability in business interactions. One such mechanism is international commercial arbitration. In light of the expanding trade and investment flows between India and UK, the need for an effective, reliable, cost-efficient, and timely dispute resolution process has never been more pressing. In international commercial arbitration, where the parties hail from two distinct countries, such as India and UK, the arbitration framework plays a crucial role in shaping the entire process of dispute resolution. The framework not only provides the procedural guidelines for conducting arbitration, but also establishes the legal principles that govern the proceedings, ensuring fairness, transparency, and adherence to international standards. The structure of arbitration, which includes the choice of jurisdiction, the selection of arbitral institutions, and the enforcement of awards, is fundamentally influenced by the legal framework in place. The current legislation regarding arbitrations in both India as well as the United Kingdom were enacted around the same time period with similar provisions focusing on party autonomy, choice of jurisdiction, independence of arbitrators, and finality of the arbitral awards. Both countries have a single legislation for arbitration that govern both international and domestic arbitration proceedings. These regulations have been used by the parties and interpreted by the courts for more than 2 decades now. Therefore, it is important to learn from each other's experience and adopt the best practice possible to promote a business-friendly environment for both the countries. Speaking as the Chief Justice of India, I may state that India has continuously aspired to become a hub of international arbitration by building a progressive legislative framework, a pro-informist judiciary, and robust institutional support. The Arbitration and Conciliation Act 1996 was enacted with the object of consolidating and amending the law relating to domestic arbitration, international commercial arbitration, enforcement of foreign arbitral awards, and conciliation. Drawing upon the UNCITRAL model law, the Act sought to bring Indian arbitration law in conformity with internationally accepted principles and to promote arbitration as a reliable and effective mode of dispute resolution. particularly in commercial matters.
If you like the video, do like, comment, share and subscribe.